just take this picture and then cut it from here. Okay, sir. So, sir, you want to go or shall I go?
Fine, sir, I can start.
Okay, sir, please start. Yeah.
Question number 5, sources of international law. Three times repeat answer. The sources of international law refer to the materials and processes from which rules and principles of international law are derived. Understanding these sources is fundamental to identifying, interpreting, and applying international legal norms. The authoritative guide to these sources is Article 38(1) of the Statute of the International Court of Justice, ICJ, which outlines both primary and subsidiary means for determining the rules of international law. So basically, primary source is Article 38(1) of the Statute of International Court of Justice. That is the authoritative guide. So there are primary sources and other recognized sources, subsidiary sources, etc. We'll start with primary sources. As per Article 38(1) of the Statute of the ICJ, these are the main forms of international law that the ICJ applies in its decisions. International conventions, treaties. Definition. Treaties are formal written agreements between states or between states and international organizations that are legally binding upon the parties that have consented to be bound by them through ratification, accession, etc. They are often referred to as contracts between states or legislative instruments if they are multilateral and establish general rules. So basically, these are the treaties between countries or countries and organizations like UN and India, WHO and India, etc. Like that, and India, US, those kind of. The basis of bindingness. These principles of pacta sunt servanda, agreements must be kept, is the fundamental rule of customary international law that makes treaties binding. Types. Treaties can be bilateral between two states or multilateral between several states, and they can cover a vast array of subjects from trade to human rights, environmental protection, or the conduct of war. Example is G5 treaties, BRICS nation treaties, etc. Example, UN Charter, 1945, the foundational treaty of the United Nations establishing its purpose, principles, and organs. Its obligation often have a higher normative statutes. Article 103, Vienna Convention on the Law of Treaties, 1969, a treaty on treaties that codifies customary international law concerning the formation, interpretation, validity, and termination of treaties. So this is about Vienna Convention law, which is one of the important treaty in the world. So Geneva Convention 1949, core treaties of international humanitarian law. Significance. Treaties are the most direct and clear expression of states' consent to be bound by specific rules. This is one. And another is international customs, customary international law. Definition. Customary international law arises from the consistent of and general practice of states, followed by them from a sense of legal obligation. It has two essential elements that must be proven. State practice, US. This refers to the consistent and uniform conduct of states over time. It includes actual physical acts, diplomatic correspondence, public statements, national legislation, judicial decisions, and voting patterns in international organizations. For a practice to become custom, it generally needs to be widespread, consistent, and of sufficient duration. Isolated or inconsistent acts are usually not enough. Opinio juris sive necessitatis, sense of legal obligation. This is the psychological or subjective element, meaning that states must follow the practice because they believe they are legally obligated to do so. not merely out of courtesy, tradition, or political expediency. This distinguishes CIL from the mere international committee, customary international law. CIL. Formation CIL can develop over a long period or in some cases rapidly. Instant custom in outer space law after Sputnik. Bindingness CIL is generally binding on all states except for a persistent objector who consistently objected to a norm during its formation. Examples: diplomatic immunity, the principle that diplomats are immune from the jurisdiction of the receiving state. Principle of non refoulement prohibits states from returning asylum seekers or refugees to a country where they would face prosecution. Prohibition on the use of force. While also a treaty obligation in UN Charter, it exists as a strong customary norm. Significance. CAL is crucial for regulating areas not covered by treaties and for binding states that are not parties to specific treaties. General principles of law recognized by civilized nations. Definition. These are fundamental legal principles common to the major legal systems of the world. They serve as a gap filler when neither treaties nor customary international law provides a specific rule. When there is no specific rule is defined earlier, then this general principle of law comes into picture. Derivation. They are often derived from municipal or domestic law, representing common concept of justice, logic, and fairness found across different legal traditions. Example: civil law, common law in that particular region law around it goes like that. Examples: pacta sunt servanda. Agreement must be kept. Although primarily a principle for treaties, it reflects a general legal principle. Res judicata. A matter judged, meaning that a final judicial decision is conclusive and cannot be relitigated. Estoppel, preclusion, preventing a party from asserting a fact inconsistent with a previous position. Good faith, the principle that states must act honestly and fairly in their international relations and treaty obligations. Uh, re- reparation for injury is repatriation, the obligation to make amends for a wrong committed. Equity, principles of fairness and justice applied in judicial decision making. Significance, they provide a residual source of law, ensuring that the international legal system is complete and can address new situations. Subsidiary means for the determination rules of law, Article 38 1D. These sources are not law creating in themselves but serve as an authoritative guide to interpret and apply existing international law. Judicial decisions, role decisions of international courts like ICJ, PCIJ, ITLOS, ECHR, IACTHR, and arbitral tribunals are highly influential in clarifying, interpreting, and developing international law. While the ICJ decisions are not formally binding precedents on future cases, Article 59 of the ICJ statutes states decisions are only binding on the parties in that specific case. They carry immense persuasive authority and are often cited as evidence of existing international law. Examples: ICC judgments, advisory opinions, and decisions of other specialized international tribunals. Teaching of the most highly qualified publicists, juries. The writings, commentaries, and social scholarly analysis of eminent international law scholars and jurists provide valuable insights into the interpretation, development, and critique of international law. They can help to identify emerging trends, analyze state practice, and articulate legal principles. Examples: works by renowned scholars like Lassa Oppenheim, H. Latterpacht, Ian Brownlee, Rosalind Higgins, etc. The significance of subsidiary sources, both judicial decisions and scholarly writing contribute to the coherence and clarity of international law, helping judges and practitioners to ascertain the content of primary sources. Other recognized sources influences on international law. While not explicitly listed in Article 38.1, these elements significantly influences the development and application of international law. UN General Assembly resolutions, nature generally not legally binding on states. Influence. They can be highly persuasive and contribute to the formation of customary international law over time, especially if adopted by consensus or a large majority and reflect a nascent opinio juris or state practice. They serve as evidence of what states. You able to hear me?
Yep.
Yeah, okay. They
Great.
serve as evidence of what states believe the law is or should be. Soft law instruments, nature. These are non-binding instruments, declaration, codes of conduct, guidelines, recommendation that do not create legal obligation but influence state behavior. Influence over time, soft law can harden into customary international law or be codified into treaties. They reflect emerging international consensus and can shape future legal norms. Examples: the Universal Declaration of Human Rights, initially a non-binding resolution, much of which is now considered customary international law. Unilateral acts of states. Certain unilateral declaration or actions by states, recognition, protest, promise, renunciation can create legal obligation or rights for the acting state, provided they are made publicly and with an intention to be bound. Example: France declaration regarding nuclear testing in the nuclear test cases, Australia versus France, New Zealand versus France, etc. Codification and progressive development of international law. The role of the International Law Commission (ILC), established by the UN General Assembly in 1947. The ILC is a body of independent legal experts whose primary mandate is to systematize, codify, and progressively develop international legal rules. Process. The ILC prepares draft articles on various topics of international law, which are often presented to states at diplomatic conferences. These drafts frequently form the basis for uh, major multilateral treaties. Examples of ILC work: the Vienna Convention on the Law of Treaties is a prime example of successful codification by the ILC. Other significant works include the draft articles on state responsibility for internationally wrongful acts and the draft articles on diplomatic protection. Significance: codification brings greater clarity and certainty to international law, reducing ambiguity and potential disputes. Significance: codification brings while progressive development adapts the law to new challenges and emerging global norms. Before moving into relevant case laws, anything needs to be discussed here? Is a little bit tricky one.
Sir, yeah. Basically, sir, what we have to remember is they're asking for the sources of international law. So broadly, what we have to remember is, see, whatever source of international law is, we are international law anangane, who actually keeps tab on it is basically the International Court of Justice. సో ఇక్కడ ఏం రాయాలంటే మనము వాట్ ఆర్ ద ప్రైమరీ సోర్సెస్. అసలు ఇంటర్నేషనల్ లాకి ఇప్పుడు ఇంటర్నేషనల్ కోర్ట్ ఆఫ్ జస్టిస్ అక్కడికి వెళ్ళి వాదించాలన్నా మనకు బుక్ కావాలి కదా సార్, ఇంటర్నేషనల్ రూల్స్ ఏంటి ఇవేంటి అని. సో ప్రైమరీ సోర్సెస్ ఏముంటాయి, సెకండరీ సోర్సెస్ ఏముంటాయి, అడిషనల్ సోర్సెస్ ఇంటర్నేషనల్ లాకి ఏముంటాయి. సో ప్రైమరీ సోర్సెస్ ఆర్ బేసికలీ ద ట్రీటీస్ అండ్ కన్వెన్షన్స్. మీరు ఇందాక చదివారు కదా, బ్రాడ్లీ ద ట్రీటీస్ అండ్ కన్వెన్షన్స్ and all of these that are coming into it. And the secondary sources ఏముంటాయంటే judicial decisions, teachings ఉంటాయి. So there are all these philosophers, Lasso, Oppenheim, Hirsch, ఇందాక మనం కొంచెం చదువుకున్నాం కదా సార్ ప్రీవియస్ క్వశ్చన్స్, దీస్ నేమ్స్. సో వీళ్ళు జూరిస్, టీచింగ్స్ ఆఫ్ హైలీ క్వాలిఫైడ్ పబ్లిసిస్ట్ జూరిస్ వస్తాయి అన్నమాట. Okay, so these are basically the secondary sources. So what are the other sources ఏంటంటే primarily the UN General Assembly resolutions itself. అంటే అందరూ కలిసి 95 కంట్రీస్ కలిపి రెజల్యూషన్స్ పాస్ చేసాయి. సో దట్ కెన్ బి ట్రీటెడ్ యాజ్ అ ఇంటర్నేషనల్ లా. అండ్ basically what are the other things like soft law instruments like United Development UDHR and United Declaration of Human Rights. Okay, so these like వాళ్ళు డిక్లరేషన్స్ లో రాసుకున్నారు కదా ఈవీ గైడ్ లైన్స్ అని. మనకి లాస్ట్ టైం వి స్టడీడ్ సంథింగ్ అబౌట్ ద గ్రీన్ థింగ్, రైట్, where there were a lot of objectives which can become like soft laws. Okay. And then there are some unilateral acts of states where we can like for example like world ఇంకా అందరి న్యూక్లియర్ టెస్ట్ చేయలేదు కదా, సడన్ గా some country does nuclear tests. So how do we deal with it in an international law? So is it recognition, protest, promise, renunciation? And if somebody comes to the ICJ, how we should be dealing with it? So three things are primary, secondary, other sources. Finally, as a codification of these international laws, ela chestaru. So there is an International Law Commission, ILC, which is established by the UN General Assembly, which does these, prepares the various drafts, sends it to different countries, diplomatic conferences, avani chesi, final ga they codify anamata, because all the countries have to accept it. So that's what it is. Broadly, you remember the
accepted but not binding.
Not binding, because అంటే అది మోనోయిస్టిక్ డ్యూయలిస్టిక్ అవి చదువుకున్నాం కదా సార్. డిపెండ్స్ ఆన్ కంట్రీ టు కంట్రీ.
I'll move to case laws.
Yes sir, yes.
The Lotus case is between France versus Turkey. A seminal case provided crucial insights into the formation of customary international law and the limits on state sovereignty. Facts. A collision occurred on the high seas between a French steamship, the SS Lotus, and Turkish collier. 8 Turkish nationals died when the French officer of the watch, Lieutenant Demons, arrived in Turkey. He was prosecuted and convicted for manslaughter. France protested, arguing that Turkey lacked the jurisdiction under the international. I think we read this in first semester, Lotus case. Did Turkey violate international law by initiating criminal proceedings against the French officer? PCIJ ruling, the Permanent Court of International Justice held that Turkey had not violated international law. The court famously articulated the Lotus principle: restrictions upon the independence of states cannot therefore be presumed. In the absence of prohibitive rule, a state may act as it wishes. Significance for sources. It firmly established that customary international law arises from consistent state practice combined with opinio juris. For a practice to become prohibitive custom, states must have refrained from acting or acted in a certain way because they felt legally obligated to do so, not merely out of convenience. The case highlighted the burden of proof for establishing a prohibitive customary norm. France failed to prove a custom against Turkish jurisdiction in such circumstances. It remains a cornerstone judgment for understanding the formation and evidence of customary international law. This is one of the famous case, Lotus case.
Yeah, so basically what happened, sir, I think the UN charter కన్నా ముందే ఇది ఫామ్ అయినట్టుంది. 1927 case, very old case. So that's why it is called the Permanent Case Court of International Justice. But the case is important because it highlighted the Lotus principle. So basically what it is saying is, if there are no international laws, then the state law prevails. Okay, and the absence of it doesn't mean that a state may act as in whatever way they want. Okay, so opinio juris ante basically it refers to belief that I think a state's actions are legally obligatory. Okay, rather than ఇది మా హ్యాబిట్, ఇది మా courtesy ఇట్లా చెప్పడానికి లేదు అని అనుకుంటున్నాను. but we can
That's it.
look into this. That's what I read last time. So broadly, this is what it is, sir. So the France guy, whoever the lieutenant was, when he came to Turkey, he was arrested, and the International Court of Justice said, yes, ఇక్కడ ట్రయల్ చేయొచ్చు,
Yes.
టర్కీలో ట్రయల్ చేయొచ్చు.
Turkey has the authority to prosecute them.
Nice.
Nicaragua versus United States. This landmark case is a paramount for understanding the relationship between treaty law and the customary international law and the evidence required for customary norms. Facts of the case are Nicaragua accused the United States of violating international law by supporting the Contra rebels, mining Nicaragua harbors, and engaging in other hostile acts. The US challenged the ICJ's jurisdiction, arguing its actions were covered by a multilateral treaty, the UN Charter, and that the US had a reservation excluding the multilateral treaty disputes from the court's jurisdiction. Nicaragua accused US. The US said UN Charter or ICJ is beyond its acting beyond its jurisdiction. ICJ ruling, the International Court of Justice asserted jurisdiction. It ruled that the prohibition on the use of force, Article 24 of the UN Charter, and the principle of non-intervention exist independently as norms of customary international law, even if they are also enshrined in treaties. Significance for sources, parallelism of sources. The court explicitly stated that treaty law and customary international law can exist in parallel, governing the same subject matter. A state bound by a treaty norm is also bound by a parallel customary norm, meaning that even if a treaty obligation does not apply due to a reservation, the customary norm might still bind the state. Evidence of custom. The case elaborated on the requirement for a state practice and opinio juris for the formation of customary international law. The court looked at UN General Assembly resolutions, statements of state representatives, and national legislation as evidence of opinio juris and consistent state practice. Persistent objector. The court implicitly acknowledged that a state cannot be a persistent objector to a preemptory norm just cognizant, like the prohibition on the use of force. It significantly clarified how customary international law is identified and applied, making it central to LLB studies on the sources of international law. So that's about the case. This is basically Nicaragua because of US violating international law. They went to ICJ, and but US, as usual, they mentioned ICJ is acting beyond its jurisdiction. Velu sir, anything you want to add here? Yes.
Yeah. See, basically what they're see Nicaragua లో ఏదైతే మైనింగ్ హార్బర్స్ వీళ్ళు ఉన్నారో రెబల్స్ ఉన్నారో they're against the government, but because US wanted some of those mines, they started supporting them.
Yes.
So and the US had the audacity to say, as per the multilateral treaty అంటే UN చార్టర్ లో మనం రాసుకున్నాం కదా మీకు దట్ పీస్ ప్రివేల్ చేస్తామని, వాళ్ళ బేసికలీ లెట్స్ లైక్ కాశ్మీర్ వాళ్ళని సపోర్ట్ చేసినట్టు సార్ అది. అండ్ దే ఆర్ సేయింగ్ దట్ వాళ్ళకి రైట్స్ ఉన్నాయి, వాళ్ళకి హ్యూమానిటీ ఉంది, దట్స్ వై వీఆర్ డూయింగ్ దిస్ అని యుఎస్. అండ్ యుఎస్ హ్యాడ్ ఎ రిజర్వేషన్ ఎక్స్క్లూడింగ్ మల్టీలాటరల్ ట్రీటీ డిస్ప్యూట్ ఫ్రమ్ కోర్ట్స్ జ్యూరిస్డిక్షన్. సో వాళ్ళు యుఎన్ చార్టర్లో ఉంది కాబట్టి కోర్టు జ్యూరిస్డిక్షన్లో లేదన్నారు వాళ్ళు.
Because it is under the UN Charter and చెప్పి US supported.
So the ICJ said, yeah, you might be having smart lawyers, but they asserted jurisdiction. It ruled that prohibition on use of force and the principle of non-intervention exists independently as norms of customary international law. So, principle of non-intervention, నీకు basically custom international law lo you are not supposed to intervene in others' affairs. Okay,
Other country
and this
internal affairs.
customary law and the multilateral treaty are both separate items. So they exist independently. So just because multilateral treaty unte, custom international law doesn't cease to exist. That's what the court said, sir.
Yeah.
So basically they exist in parallel. A state might be bound by a treaty norm, is bound by the parallel customary norms also, which are there in their country, right? Adi. So more or less that's what it was.
Yeah.
And the court also importantly looked at UN General Assembly resolutions of state of representation national events of the opinion juries and consistent state practices to validate this theory. So finally Nicaragua won basically.
Yeah. But US not accepted.
వాళ్ళు ఎలాగే ఇప్పుడు ఇప్పుడు ఇండస్ వాటర్ ట్రీటర్ ఉంది సార్. ఇండస్ వాటర్ ట్రీటీ అసలు మనం ఆర్గ్యూ కూడా చేయలేదు. పాకిస్తాన్ వెంట్ అండ్ సెడ్ ఓకే ద ట్రీటీ మస్ట్ బి ఆనర్డ్ అని హైకోర్టు మొన్న ఇది ఇచ్చింది, సారీ ఐడబ్ల్యూటీ ఇచ్చింది, ఇంటర్నేషనల్ కోర్ట్ ఆఫ్ జస్టిస్ ఐడబ్ల్యూటీ మీద ఇచ్చింది.
Okay.
ఇండియా సెడ్ ఓకే యూ కెన్ యూ వాట్ ఎవర్ యూ వాంట్ బట్ వీఆర్ నాట్ గోయింగ్ టు ఫాలో. అది సార్.
If it is in their favor, they go with it, whichever the country is.
Exactly.
The ruling is in their favor, they respect the decision, or else will not.
End of the day, muscle matters, sir. That's what it is.
I'll move to the rest. Salient features of international law sources, hierarchy debate. While Article 38(1) lists sources, it generally doesn't imply a strict hierarchy, except that primary sources are applied before subsidiary ones. In practice, treaties are often applied first, then custom, and then general principles. However, just cognized preemptory norms are universally accepted as higher norms from which no derogation is permitted. Prohibition of genocide, torture, slavery. Dynamic nature of customary international law is not static. It continues to evolve based on changing global practice and a shared belief in legal obligation among states. This makes international law adaptable to new global challenges. Judicial influence. Judicial decisions, particularly those of the ICJ, play a crucial role in interpreting, clarifying, and at times shaping the development of international legal principles, providing authoritative guidance. Codification and codification's rule. The codification work of the ILC is essential for bringing greater certainty, systemization, and progressive development to international legal, moving from unwritten custom to explicit treaty law. Interaction of sources. The different sources are not mutually exclusive but often interact and reinforce each other. A treaty can codify existing custom, or persistent state practice can lead to the formation of new customs. What we have said till now is that concludes this section, and section. This is Peter Price. Interesting topic. Sir, you want to take it? I just need to attend a call.
Yeah, sure, sir, sure. I'll go ahead with the 6th one unless people have any questions on the 5th. Okay. 6th one is state succession. That means what kind of rights and duties are there for a state. So state succession refers to the replacement of one state by another state in the responsibility for international relatives in that particular territory. So this is a complex area of international law, often with significant political implication, addressing the legal consequences of territorial changes. It can arise from various events such as decolonization, secession, unification, dissolution, or secession of a territory. So, if when they are doing this, what is a legal framework? So, state succession ante oka state మొత్తం either it is becoming part of another country or దాని సక్సెసర్ మారుతున్నారు అనమాట. ఫర్ ఎగ్జాంపుల్ హాంకాంగ్. Hong Kong was ruled by United Kingdom, and then it was given to China. So when they're doing this, what is the international legal framework? Well, customary international law plays a significant role. Key attempts to codify the rules include Vienna Convention of Success of States in respect to treaties. 1978, this is one of the conventions that kicks in, deals with the effect of state succession treaties. Not all states have ratified, but many of its provisions are considered reflective of customary law. And the other one is Vienna Convention of States in respect to state property, archives, and debts, addressing the allocation of states' assets and liabilities, and not universally ratified but infringed. So, context and types of state succession ఏంటంటే what are the different types of state succession? First, we have to understand the different types. So, first one is decolonization, and newly independent states. When a former dependent territory achieves independence, the independence of numerous African and Asian nations from colonial rule in the 20th century. The clean state principle often applies to treaties, allowing new states to choose which pre-existing treaties they wish to continue. So, for example, India got independence, Pakistan got independence, or a lot of countries got independence from the colonial state. So, once they do this, they have a clean state, and they have a choice of uh, basically what they're saying, allowing new states to choose which pre-existing treaties they wish to continue. So pre-existing treaties they can continue. Which one they want to continue, which they cannot want to continue, they have the choice and matter because they are a new state. And then second one is unification of states. This is a interesting thing where two or more states merge into a single successor state, and the predecessor state continues to ceases to exist. And what, for example, German reunification, where the East Germany and West Germany were united in 1990. Principles of continuity for treaty generally applies, meaning treaties of predecessor states remain in force for the respective territories while they are previously applied unless otherwise agreed. So in this issue and whatever treaties they have done in the past need to be honored by the unified state. And the other one is secession, which is basically separation or part of a state. A part of state's territory secedes to form a new state while the predecessor continues to exist with a reduced territory. So South Sudan seceding from Sudan, or Eritrea seceding from Ethiopia, or Bangladesh seceding from Pakistan. Treaties of the predecessor state generally continue to apply in the remaining territory. For the succeeding state, the situation is more complex, sometimes leaning towards continuity, sometimes towards a clean state. So, and dissolution of a state. So, breakup. A predecessor state dissolves and ceases to exist, and its former territory gives rise to two or more new countries, like the dissolution of Czechoslovakia into Czech Republic and Slovakia, the breakup of USSR or Yugoslavia. Generally, the principles of continuity for treaties is favored for successor states, especially for localized treaties. The fifth one is secession or transfer of territory. The part of state territory transferred to existing state. The ceding state continues to exist, as does the acquiring state. So basically, the United States purchase of Alaska from Russia is considered as secession or a transfer of territory. So treaties of ceded states cease to apply. Whatever treaties of the ceded state cease to apply for the transfer territory, while the treaties of the acquiring state extends to it. Principles of moving treaty frontiers. So basically, when a part ఇచ్చేసినప్పుడు so Russia, whatever treaties they have signed will not be applicable for that particular state. The United States treaties will start applying for. Also, what are the legal consequences, rights, and duties arising out of these treaties? One is clean state, traditionally applied to new independent states, allowing them to start fresh, not bound by treaties, but except for the certain types. So, basically, what we are trying to say here is what are the legal duties and rights and duties arising out of treaties? So, clean states are traditionally new independent states, allowing them to start first, not bound by treaties. Principle of continuity suggests successor states inherit treaty obligations. More common is in cases of unification where the predecessor state continues. And dispositive treaties, treaties concerning territories or rights linked to territories, like boundaries, rights of fish, water rights, are generally considered to pass to the successor state. Then political treaties, treaties of alliance, neutrality, or those having independent of political character of predecessor, generally do not pass. Human rights treaties is a strong government growing practice that obligation under human treaties develop upon successor states to ensure continued protection of individuals. And the state's property and archives, the immovable state property obviously cannot be moved. Property located within the territory generally pass to the new state. If located in third state, it passes to the successor. If it belongs to a territory to which the succession relates. Movable state property should be divided into equitable manner, often linked to territory contribution to its creation. And state archives, archives essential for administration of territory or relating should pass to the successor state. So now what happens to debts? This is a highly contentious area. The general principle that the equitable proportion of predecessor state debt should pass to the successor state, particularly if the debt benefited the territory concerned. No succession to odious debts. Debts incurred by the predecessor regime against the interests of the population or the purpose hostile to the territory. Odious debts cannot be counted on. The 1983 Vienna Convention provides detailed rules, often resolved by specific agreements. And nationality and citizenship, the inhabitants of the territory affected by the succession typically acquire the nationality of the successor state. International law aims to prevent statelessness. Often, individuals are given right of option to retain their former nationality to choose a new one. So, membership in international organizations. Membership is generally not transferable. New state usually have to apply for membership in organizations like the UN. Exceptions may occur if a state is considered a continuation of predecessor state. Example, the Russian Federation was widely accepted as a continuous state of the USSR in the United Security Council. And private rights, generally private rights such as property rights and contract acquired under the law of predecessor state should be respected by the successor state. However, the successor state may later alter these through its own legislation subject to international minimum standards. So these are all the types of succession అండి we have to remember. And then succession జరిగినప్పుడు ట్రీటీస్ ఏమవుతాయి, ప్రాపర్టీస్ ఏమవుతాయి, డెట్స్ ఏమవుతాయి, సిటిజన్షిప్ ఏమవుతాయి, ఇంటర్నేషనల్ మెంబర్షిప్స్ ఏమవుతాయి, ప్రైవేట్ రైట్స్ ఏమవుతాయి. వీటన్నిటి గురించి మనకు కొంచెం అవగాహన ఉండాలి. సో వీ హ్యావ్ టు రైట్ అబౌట్ దట్. And then relevant case laws. This is one Gobchikovo versus Naga Myros project, which is Hungary versus Slovakia. Hungary and Czechoslovakia signed a treaty in 1997 to build a system of locks on the Danube. Czechoslovakia later dissolved and Slovakia became an independent state. Hungary argued that treaty does not bind Slovakia. Did the 1977 treaty, a bilateral treaty and obligations related to a particular river, survive the dissolution of Czechoslovakia and bind Slovakia as a successor state. And ruling, the ICG held that the treaty remained in force and was binding on Slovakia. It emphasized the Article 12 of Vienna Convention of Treaties, reflecting customary international law. The treaty established a territorial regime and thus survived the state succession. Significance and affirmed the principle of continuity for dispositive treaties in cases of state succession, underscoring stability in territorial arrangements. సో ఇన్ దిస్ ఏంటంటే చెకోస్లోవేకియా డిజాల్వ్ అయిపోయింది కాబట్టి హంగరీ సెడ్ ఆ రివర్ మీద వీళ్ళకి హక్కు లేదు అని, బట్ ఇట్ డజంట్ వర్క్ దట్ వే. ఇట్ ఈస్ రిఫ్లెక్టెడ్ ఇన్ ద కస్టమర్ ఇంటర్నేషనల్ లా. అండ్ దెన్ స్లోవాకియా, the ICG held that treaty remained in force and was binding on Slovakia. Okay. affirmed the principle of continuity for dispositive treaties. So the next case is basically Bank of Ethiopia versus National Bank of Egypt in Ligori. After Italy's conquest and perpetual annexation into Ethiopia in 1936, the Italian government dissolved the Bank of Ethiopia and transferred its assets to Italian bank. Following Ethiopian's liberation, the restored Ethiopian government sought to recover assets held abroad. Could a decree by occupying power, which had not achieved lawful sovereignty, effectively dissolve a national institution and transfer assets such that the British courts would recognize the transfer? The English court refused to recognize the Italian decrees that purported to dissolve the Bank of Ethiopia and transfer it. Particularly, UK had not the time to recognize Italy de jure sovereignty over Ethiopia. The acts of occupying power were deemed contrary to public policy and international law. Significance in it, while not a direct case of formal state succession between two, it illustrates the principle that the rights and legal status are not altered by illegal occupation or perpetual annexation that does not constitute a lawful succession. It underscores the succession process must be lawful to have recognized effect on the property and obligations. So interesting case ఇక్కడ ఏంటంటే when the Italy went and annexed into Ethiopia and they dissolved their state bank లాగా వాళ్ళ బ్యాంక్ ఆఫ్ ఇథోపియాని డిజాల్వ్ చేసి అసెట్స్ అన్ని ఇటలీ మూవ్ చేశారు. సో ఇథోపియా at that time in 1937, I think when the annexation didn't happen properly, they went to UK's courts because at that time the ICJ was not there, I guess. So UK ఎందుకు వెళ్ళారంటే UK didn't recognize the Italy's annexation into Ethiopia. So the UK courts వెళ్ళినప్పుడు UK they said that yes, you have to return all the properties which were taken by Italy to the Bank of Ethiopia in Ethiopia. Okay. So broadly, key principles ఏంటంటే continuity versus clean state, a central tension with different approaches favored for different types of succession and different types of obligations. And then you have to remember this ut possidetis juris, the principle that emerging states inherit the administrative boundaries they held as colonial internal territories, crucial for preventing boundary disputes. Equitable distribution, guiding principle allocation of state property, archives and debts, and protection of human rights, of course, you have to protect. And then Vienna Conventions honor చేయాలి, both 1970 and 1983. And illegality exception, acts of aggression or illegal occupation generally does not create a lawful basis for state succession. So these are the key principles which we have to remember. Okay, so we are moving on to the seventh one. My suggestion is, Rosu, let's close it till here. And maybe tomorrow we'll do 7, 8, 9, 10, 11. 5 ఉంటాయి కాబట్టి 1.5 hour లో క్విక్ గా క్లోజ్ చేసేద్దాం. ఓకే
ఫైన్ సార్.
ఉన్నారా? లేకపోతే
ఓకే అండి.
ఓకే మేడం. ఓకే
యా యా
ఓకే థ్యాంక్ యూ.